Good evening. This is Rahul Reddy. We're live here from Houston, Texas. Every Tuesday, we do bring in immigration updates. Rebecca, what do we have today?
Yeah, so we'll discuss the recent Supreme Court hearing on the birthright citizenship issue and what the potential consequences would be when they issue their decision on that. We'll discuss layoffs for visa holders, particularly H-1B workers. What immediate steps should you be taking if you are facing a job loss in H-1B status? We'll also discuss the biometrics RFEs that we have been kind of reporting on the past few weeks. Biometrics RFEs being issued for employment-based petitions, I-140s, and H-1Bs, I-129 petitions for the first time ever. And so we'll discuss what the potential impact could be on those applications, particularly H-1B extensions and transfers of those biometrics RFEs. And then we'll also discuss remote work for H-1B workers. Is working entirely remotely okay? What do you need to keep in mind as an employee, as an employer, and what do you need to consider to make that arrangement work? So on the birthright citizenship issue, Rahul, what did the Supreme Court have a hearing on recently? I think just at the end of last week.
This hearing is about the procedural aspect, whether one particular district can give a judgment, can block the entire nation, or it only can block in that particular district, though. Because as we have seen, several judges have blocked this entire nationwide. I just want to explain to people how the system works, is that there are district courts. These are where the judges are appointed by the President of the United States and approved. They have been approved by the Senate. The majority of the Senate approved them. Now, however, after the district courts, then we have circuit courts, and then we do have the Supreme Court at the final. What some of the judges have done is that they not only, let's say, for example, the Seattle district judge not only blocked in the Seattle area and also in Washington state area, but also blocked the entire nation. And several other judges also did the same thing. So here, what the Trump administration is arguing is that the district courts cannot have a nationwide injunction. They may or may not. They may have it in the local, but they cannot in the nationwide. The Supreme Court is not hearing on the merits whether or not the Trump administration could issue an executive order which is valid for banning the birthright citizenship, or that's not the issue. It's only the procedural issue whether the courts can issue nationwide injunction. And can you explain what's going on in the Supreme Court, Rebecca?
Yeah, so again, the current hearing is only on this injunction matter. It's not on the merits of the case. So the justices haven't gotten to the question yet of whether the attempt to revoke birthright citizenship is constitutional or not. So we're still awaiting the decision from the Supreme Court on this injunction issue, but I mean, based on kind of some of the reports of how the hearing went, it did seem like the justices were skeptical of eliminating the need for the nationwide injunction. They seem to be leaning towards, even though they didn't address the merits specifically, some of them seem to hint that the executive order would be found unconstitutional. They were sort of debating whether it would be faster for some other procedural options to be in place rather than an injunction. So we will need to wait and see what their decision is on that. There is the possibility that if they do allow the government to continue with kind of localized injunctions more on a state-by-state basis, it could kind of lead to a sort of patchwork situation where in certain states the birthright citizenship ban is in place and in other places it isn't. We're hoping that's not the case because that would lead to a lot of confusion and people potentially just moving state to state depending on the policies or the court orders in a particular state.
Yeah, potentially, if the judgment comes that the judges have authority only for that particular district, not for the entire nation. So what will happen is that for the some of the places, for some of the states, in some of the districts, for example, in some of the Texas districts, the judges did not issue the injunction. So these people, if they want to give birth and they want to have their children to be having having the U.S. citizenship, they may have to deliver the baby in a different state. Now, I'm not the doctor telling that what is healthier, what is not healthier for the pregnant lady or the child, but I'm just telling the legalities of it that at least that may happen. That is the worst that can happen right now. Now, of course, the entire executive orders is also challenged on the constitutionality. Then that may take a couple of years, maybe a year, maybe 2 years for us to get the hearing. And if the Constitution, if it's completely ruled that it's unconstitutional, irrespective of where the person is born, they will get a U.S. citizenship. But then you have to completely rely on the Supreme Court judgment that may come out at a later date. So we'll keep informing you how the Supreme Court is going to stand on, if we have to look into which districts are okay for the children to be born, which districts where if your children are born there, then they may not be given, at least for temporarily, they may not be given citizenship. We will inform you soon on that thing. Um, Go ahead, Rebecca, the second issue.
So on the topic of layoffs for H-1B workers, so sometimes companies, of course, terminate you immediately. Sometimes you're given a fair amount of notice. So we have, talked to many H-1B workers where they say, the company will be laying me off, but I have, 3 months until then. Regardless of when you find out or how much time you have, what should be an H-1B worker's considerations or steps or preparations when they do find out that their H-1B employment is going to end?
First thing they need to look into is, when does their H-1B expires? For example, if they got laid off on May 30th, let's say on the day of May 30th, when is the actual H-1B for that particular company is expiring? If it is expiring, let's say more than 60 days, for example, if it's expiring May 30th of 2026, though, everybody knows that there is a 60-day grace period that is allowed, that once the layoff started, that means from June 1st onwards, you have until about July 27th or July 30th or so for you to stay in the United States, legally in the United States. And if your spouse is an H-4 EAD, they can continue working on the H-4 EAD. So that can be done for the first 60 days. After that, you have to look into what are the options that you have. Generally, though, we advise people that you can move into B2, which allows you to stay for a period of 6 months in the United States. So, for example, if you got laid off on May 30th, then you have until July 30th to stay. From July 30th onwards, you have up to 6 months, which is up to January 30th of 2026. You can apply for B2. USCIS in its website clearly indicated in March of 2023 that they are encouraging people to move into B2 if you if you lose the job, so that you can find another job and search for another job, which you can do so. That's one thing that you can do. If you have a H4 option, definitely H4 option is much better than H1B option, B2 option, because it's more longer than 6 months. You can move into F1. Now, we do not recommend people to move into day one CPT F1s, though. But yeah, you can move into F1. You can file a premium processing and get the things adjudicated faster and stay in United States on F1. That's also a possibility for you to do. Now, you can always move back to outside the country, and you can always move back to outside the country and come back on H1B at a later date without going through the lottery system. Now, one thing people get scared is that once I move to H4, or once I move into B2, F1, or once I go outside the country, do I actually need to go through the lottery system? No, you don't need to. If you have not completed your 6 years of H1B, let's say, for example, you completed only 2 years of H1B, You can always come back into H-1B with either B2, F1, or H-4 without going through the lottery system, or when you leave outside the country. At any point of time, there is no time limit, whether you have to do it right now. It can be done in the next 10, 20, 90 years. You can always come back into the H-1B if the priority date is not current, if you have an I-140. So you can always come back into H-1B at any point of time. You don't have to worry about that. However, when you come back, if you don't have an I-140 approval, you can only use the remaining part of the 6 years that was left out for the H-1B. For example, if you use 2 years, only 4 years is left out. Now, Rebecca, some people are choosing to move into some consulting companies with a in-house project because they feel that it's easier to move. Some company says they can file a H-1B. Is it advisable for them to go to another company with a in-house project?
Not if there isn't actual specialty occupation work at that H-1B employer. So that is still a requirement under the current regulations. The H-1B modernization rules in January now requires proof of bona fide specialty occupation work that's available for the beneficiary. So if the H-1B employer is primarily a consulting company, they don't really have their own in-house products that they are developing, and there isn't a project available that they can put you on. It really, it's, we understand how it can seem like an H-1B transfer within the 60 days would be safer or a more attractive option, but actually in the long run, it is potentially a lot more damaging to move to that sort of H-1B rather than just doing a B2 change of status. With B2 change of status, you don't have to show any specialty occupation work. You're just, the USCIS website that Rahul mentioned specifically states that the B2 change of status is an option for laid off visa holders to give them more time to job search. And you can state in your B2 application written statement that you are filing for a B2 change of status in order to continue your job search in the US. That's absolutely fine. And that is a much better and kind of safer way, especially now that USCIS has the bundling policy where if 2 or 3 months into your B2 application being pending, even if it's not approved yet, if you get a job offer from a company willing to do your H-1B application, they can file the change of status from B2 to H-1B in premium processing, and USCIS will bundle the pending B2 along with the new H-1B application and approve both at the same time, and you can be back in H-1B status and back at work within 3 weeks of the H-1B application being filed. So it really is easiest now more than it ever has been in the past to kind of transition from H-1B to B2 and back to H-1B. We don't know how long that will continue under the current administration, but that policy is still on the government's website right now.
One thing is that if you collaborate or if you conspire to commit fraud on United States Immigration Authority, though, you may be barred forever to come back into the United States. We see a lot of times now, recently, especially when people file for the H-1B with in-house projects, which we know what those kind of things are, and have provided money for the company to file it. You are part of the fraud, though, and they may bar you forever to come back into the United States. So you don't have to go through this expensive, illegal, criminal, felony activity to be maintaining the legal status. You have options of B2, you have options on F1, and you have options of going outside the country and coming back too. So think of long term, don't fall into the trap of filing. And it is cheaper, guys. It's just, if you consult us, just with consultation, we can help you file the B2 by yourself, which may cost you less than $1,000, and including the filing fees, to just get onto B2 for a period of 6 months. So that's definitely USCIS is recommending it in its website. And we have done so many times. Rebecca has already pointed out that even if the B2 is pending, you get a job offer, then you can move back to H-1B. This allows you to get 2 months of your grace period, and then afterwards you have 6 months. So you have 8 months to stay in the United States legally. So don't pick options of the of going to H-1B without a real job. Now, does the 60-day grace period apply for the people who are in adjustment of status, Rebecca?
No, so that is an important distinction that we see sometimes, is that people who have been on H-1B for so long are used to the 60-day grace period, and they assume when their I-45 is pending that they will have that same grace period. Technically, the rule under the I-45 adjustment of status, if it's based on an I-140 filing, is you are supposed to have a valid job offer, full-time job offer, from the time the I-45 is filed until you get the green card continuously. There's no grace period for absence of that job offer in either from the I-140 petitioner or in a same or similar occupation, which is, with a different employer, which is doable after the first 6 months that the I-45 is pending. So one important thing to keep in mind is it's continuity of a job offer, not necessarily continuity of employment nonstop from the I-45 filing until approval. But technically there are ways that you can kind of, if you know that you have a termination coming up, there are ways that you can secure a job offer beforehand to cover gaps in employment, but you do have to plan ahead for that, because there technically isn't a grace period for having a job offer in order to support your I-45 for however long it takes to be approved.
Going to the third topic of biometrics. Now, of course, we have filed so many H-1Bs extensions, transfers, I-140s. We were never been requested for biometrics for the H-1Bs. What's going on, Rebecca, right now? Why are they asking biometrics for only some people and not for all the people who are filing H-1B extension, H-1B, and also H-1B transfer, and also I-140?
Yeah, so definitely the only biometrics RFEs for employment-based petitions, I-140s and I-129s, that we are seeing so far are for beneficiaries that have some sort of criminal record, although that is also sometimes an overstatement. It doesn't necessarily mean that you are convicted of a crime or arrested. It seems that if you have had any interaction with law enforcement, if you were on a police report at any time, basically if you were ever in the National Criminal Database for any reason, not necessarily as a convicted criminal, but for any sort of citation, those are the people who are getting the biometrics RFEs on their pending I-140s or I-129s right now. And it definitely seems to be kind of along the same lines of what was happening to the F1 students. It seems like it's the same people at DHS who wanted to cross-check the CFS database against the National Criminal Database, and are now doing the same thing for people in I-129 and I-140 beneficiaries. So far, the biometrics RFEs are usually, there is an RFE first asking for confirmation of the beneficiary's address, even though the I-140 form and I-129 form usually contain the beneficiary's residential address. Then once the address is confirmed, there is an RFE sent basically for the biometrics appointment for the beneficiary to attend a biometrics appointment at a local application support center. And so what have we been hearing on how those biometrics appointments are going, Rahul?
They're just getting the biometrics done. I haven't seen any arrest for these people. I have not seen any denials of their change of status, extension of status, or I-140s based on these biometrics at this point of time. I do fear, though, that this may hunt at a later time, that we have seen that the administration is planning something which we don't know what they're planning. If you recall, Rebecca, that in April 1st of 2025, that's just 1.5 months ago, we have seen the visa revocations and later on the civil terminations for the student visa people who are in the similar category of what these people are. At that point of time, a lot of people ask the question, what about the people who are on H-1B, L1, and H-4 visas? No, you guys are safe. That's what we told. It seems that they are planning something, because according to the regulations, there is a discretion process that the administration can use, granting the extension, change of status, or I-140. Could they evoke, because this person is having a criminal record? Can they invoke the discretion? At this point of time, they are not. Could they now have a different policy that if a person is involved in any criminal activity, they will use their discretion and will not approve the H4, H1, and I-140? They could, but at this point of time, they are not. There is no policy that these H1B extension should be denied, so they're not denying it right now. Could they deny it later on? There is a chance for it. Now, those people who are under this kind of things where they have any criminal records. Now, what is a criminal record? Let's say, for example, there is a speeding ticket and you're supposed to pay the speeding ticket by May 15th, and you missed out the date somehow and you never went to the court, or you paid the fine online. So then the arrest warrant will come out. Hey, you didn't pay the money or you went to the court. The arrest warrant will come out automatically. It's automatically generated. Now, you all of a sudden you will go to a lawyer. Hey, I got an arrest warrant. What do I do? They normally what they do is that they pay it instead of $100, you will end up paying $300 and get everything waived. Now, that's considered to be a criminal for the purpose of the immigration. A arrest warrant has been issued. So for those kind of people, we have seen civis terminations. Could that haunt in the time when we are coming to H1B? Maybe it could. Maybe it could. At this point of time, it's not. So these kind of people, we do not want them to travel. We do not want them to go to stamping, even though you are allowed to stay in United States, travel in United States, but not outside the country.
Right.
Going to the fourth topic, Rebecca, I have an H1B and I am located in California. I'm working in California. Now, my job is remote, and my wife is in Dallas, Texas, and my company doesn't want to file an amendment because it's an expensive process for them. Can I just go to Irving and stay there, not tell anybody?
No, yeah, not a good idea. So even if your job is 100% remote, you're authorized to work entirely from home. The LCA and the I-129 forms still require the full street address of your work location, even if it is a home address. And if that home address is going to change to somewhere outside the metro area where your original LCA and I-129 were approved for, that requires an amendment. So even if your home address changes, yeah, you really need your employer to file an amendment before changing your home work address. We are seeing an increase in site visits, and those site visits can happen at a residential home address if that is what is listed on the application as the work location. We have had instances of FDNS officers visiting people's home because that is listed as the work location on their LCA. And if they show up at a home that is listed on the application and you're not there and it's a different person, a different family, it's clear that you haven't lived there in a while, yeah, they definitely can open an investigation, and you can be found to have been failing to maintain status for however long you were not working where the application said that you were working.
And please do not lie to the FDNS. If there is an FDNS visit and if you are located in Dallas, your LCA is in Bay Area, the answer you're going to give is that you are working in Dallas. You do not lie to them. I have had people that lied and that got into bigger trouble, barred forever to come back into the United States because that's misrepresentation. It may be a status violation that you're working in Dallas instead of Bay Area where your LCA is, which can be covered, which we don't advise you to do it, but if that can be covered, but if you tell a lie to the officer, it is going to be a problem. We had one time, one guy working at a different location, and the guy said, hey, and I'm actually working at the LCA location. The guy said, hey, show me the driving license. Show me, he gave some of the ticks where the person asked to show, and then the driving license is in Dallas for these guys. So lot of difficulties. Don't do that. Don't ever do that thing. If ever you get cornered into a situation, please contact an immigration lawyer. That'll be much better before you speak with any official. Let's go to question and answers. Rebecca, unless you have anything else.
No.
Vijay Chadlavada has this question. He is transferred to UK, but he's actually on the payroll of United States right now. And after completing 1 year in UK, can he come back into United States and file for the L1A application? And probably his probable target will be EB1C at a later date, which green card process is faster than the EB2. The answer is clearly no. You will not be eligible for L1A. You will not be eligible for the EB1C. The reason you will not be eligible for EB1C and L1A is that you must have been working for a foreign corporation. To show that you're working for a foreign corporation, you must be on the payroll of the company there. If you are not on the payroll of the company of the UK, then you cannot get a L1A or EB1C.
Krishna is asking, can an H4 EAD holder work for Uber along with their full-time job? So doing Uber, driving on the side. That is absolutely fine. On H4 EAD, you have unrestricted work authorization. You can work as a contractor, as a full-time employee. You can work multiple jobs. You can not work at all. It is all an option on the H4 EAD.
Question from Kiara Katie. DOL prevailing wage submission was done on May 5th. What is the processing time? It's after it's been submitted. It's about 7 months right now to get a prevailing wage.
Jigar has a question about his spouse who got the EAD based on, so it sounds like his I-140 isn't approved yet, but the H-4 EAD was issued based on the AC-21 provision where the perm has been pending for more than 1 year. Yes, so that's absolutely fine. It's rare for that. Most of the time we get the H-4 EAD at the point where the I-140 is approved, but technically you can apply for the EAD during that 1 year point after the perm has been pending. So if it's been issued, then it is effective and she can use the EAD immediately.
Question from Avi Narayanan. Can someone travel on a tourist B1, B2 while I-130 is pending? I definitely want you to consult an immigration lawyer. The reason is that when somebody filed an I-130, you're expressing that you want to permanently settle in the United States, and you're coming on a B2, you're telling that you temporarily want to visit United States. So there are a lot of factors that the lawyer need to take into. When did you got the B1, B2? After the I-130 has been filed or before? If it's been filed afterwards, did you mention about the I-130 in B2? If you got the B2 approval after the I-130, if you got the B2 approval before they filed the I-130 afterwards, and what category the I-130 has been filed? Is it an F4 category? Is it an F2A or F2B category? So all these things need to be considered. And when you're entering into United States, there are a lot of things you will go through scrutiny. So it's better to speak with a lawyer, be prepared rather than come in and get deported.
We have a question on whether H-4 EADs are still being adjudicated along with an H-1B if all three were filed together in premium processing. For the most part, yes. If all three were filed concurrently and it's in premium processing, we are still seeing that the H-4 and EAD get approved relatively soon after the H-1B approval, not necessarily on the exact same day. What we're usually seeing is that for some reason, the H-4 and EADs are still being separated and sent to a different service center, even though they are all filed at the same lockbox mailing address. At the lockbox, they are separating the H-1B, sending it to one service center, and the H-4 EADs are getting sent to another service center. And maybe because of that different service center, it's taking about an additional 2 weeks after the H-1B is approved to get the H-4 and EAD approved. But it's still much faster than, what it used to be when the H-4 and EAD were just in regular processing and pending for, 6 to 8 months beyond the H-1B being approved. So for the most part, it is still simultaneous that we're observing right now.
Jaswant, if we can do multiple jobs on H4 EAD, do we need to inform both the employers that you're doing multiple jobs? Under the immigration law, there is no rule that says that you have to inform both employers about it. The morals and certain other things, we are not concerned about it. But as far as the immigration law, I'm answering, you are under no obligation, none whatsoever at all, for you to inform both the employers. There have been rumors that have been circulated that, somebody was coming in from H4 EAD. They got caught in the airport. The CBP authorities said you did not inform both the employers and they deported that person. That is a lie. That is a big lie. And the same rumor was spread around for a green card holder too. That is a lie too. That is a lie. In fact, my wife at one point of time was employed by 8 employers at the same time on green card and had no issues at all. When we filed the citizenship, also no issues. The reason is that some of these healthcare workers, they do work a lot of employers, guys. They do on call and a lot of different things they do at the same time. So they don't. There's no obligation from the immigration point of view to inform that.
We have a question from someone who is on H-4. They say it's valid until next year, but the I-94 is expiring in 3 weeks. And can they apply for an H-4 extension of the I-94? Yes. So I assume maybe the H-4 approval notice was valid till next year, but because of travel and maybe a passport that's expiring soon, the I-94 that was issued by CBP may have been cut off based on the passport expiration date, which is very common. So the good news is that you caught it before the I-94 expired. So in this case, definitely if you can't travel, maybe the easiest way to fix it, well, it depends. So one way that you could fix it is if you have the passport renewed now, you could travel again, like just going to Canada or Mexico and coming back in, and you should get the extended I-94 from CBP. If you can't or don't want to travel, you can file the H-4 extension application, the I-539 application, which you can file online on your own, or you can, schedule an appointment to have an attorney review it. It's a pretty simple form to file the I-539 online. And that will enable you to remain in the U.S. in a period of authorized stay beyond the I-94 expiration date, as long as you file it before the I-94 expires.
Question that is coming from Educational Hub from YouTube is that he's asking, is it better to be on GCEAD or H-1B under the current circumstances? Are you seeing any 485 denials for the people? There are some pluses and there are some minuses for both the things. Let me tell you some of the disadvantage in maintaining H-1B though. One, the FDNS. There are times where the FDNS will come in, and if there is any inconsistencies, let's say some of them will probe into the wage levels and may create an issue that the wage level is different, and that may lead to 485 denials, also may issue an RFE and 485s. So there are a lot of issues that need to be there. There are some advantages in maintaining the H-1B just in case if the 485 gets denied. Recently, we got some 485 denial saying the prior date is not current, when the prior date wasn't current at the time when they filed. Definitely, H-1B would have been more useful in those circumstances. But there are some disadvantages in having a H-1B. Also, more scrutiny from the USCIS with the FDNS. So it has, it has both advantages and disadvantages.
Mary was recently laid off in H-1B status, but her EB-2 national interest waiver priority date is current in June. So she's asking, can she file the adjustment of status in June during her 60-day grace period? Yes, you can. So the 60-day grace period is essentially it's still H-1B status for most intents and purposes. So you are still considered in valid non-immigrant status during the 60-day grace period, and based on that, you can file your I-485. The good news is because your EB-2 approval is a national interest waiver, I assume that means you self-petitioned for it and that it wasn't based on an employer-sponsored EB-2. So if that is the case, then you don't need an employer to sign the I-485J supplement on your behalf. You can just file the I-485 application on your own based on the self-petitioned NIW.
Shankar says that he has an out-of-state speeding ticket and he paid the fine, hired a lawyer, paid the fine, but the driving license is suspended plus fine. Definitely, it's a criminal offense, but normally in normal traffic violations, you don't have to report. But if your driving license has been suspended, though, that seems to be something major. Where in Ohio, particularly, we see that, especially if you drive without insurance, that may be a major issue there. So I definitely think so. You should consider speaking with an immigration lawyer, Shankar. Because why would they suspend driving license for 6 months for a speeding ticket? So there must be some grave issue. Don't you think so, Rebecca? Driving license
Yeah.
suspension for a speeding ticket?
Yeah, I would think there are some sort of aggravating factors there beyond just speeding. Let's see. Pramod is traveling soon and has a valid H-1B visa stamp. His current I-797 approval notice expires in August this year, but it's already has an extension approved until 2028. And he's asking what should he present to the CBP officer when he returns. So you should present both approval notices, the current one that's valid until August this year and the most recent extension approval notice that's valid until 2028. With both of those and your current valid visa, CBP should issue you an I-94 at entry valid until 2028, which is the extension end date. Double check though as soon as you come back. I mean, this goes for everyone entering the country. Double check your I-94 as soon as you enter. Check it online. We're seeing more kind of errors in like the visa class or end dates or names, sometimes more errors than ever in electronic I-94. So check it as soon as you come in. And if they only gave you until August 2025, you can try to request a correction from deferred inspection. We've been having more trouble than usual getting corrections from deferred inspection recently. It used to be a pretty simple process, just sending an email to any port of entry under the previous administration. Right now, it is very difficult. There are a lot of ports of entry that are refusing to do it by email unless you entered through that port. Or if you can't get the I-94 updated, the way to fix it would be, after or before August 2025, just departing and coming back in again, like from Canada or Mexico, to get the extended I-94.
Question from two people have the question. Rohit and Nirata, from both of them from YouTube, has this question about the DUI, about the biometrics. Will there be an issue in the biometrics? They both have DUI. One has been expunged, one has been reduced to reckless driving. We are not expecting any problem right now, at least temporarily, for you to go to biometrics. We're not expecting, but we don't know in the long run. Keep watching this one. This is a recent development. It's an ongoing story, and we are collecting more information. So please tune in for every Tuesday, so we'll update. And if there's any untoward incident happen to anybody who's going to biometrics, we will definitely have a special bulletin. So please subscribe to our YouTube channel and also our subscribe to our RN Law group, and then subscribe to the blog so that you get any updated information from us.
So Lucky has a question about someone in L1B status who gets picked in the H1B lottery. Can they wait 2 years without proceeding with the H1 filing if they want to postpone it to increase the chances for EB1C, but not lose the lottery selection. So you can't postpone filing of the I-129 petition for that long. If you were selected in the March 2025 lottery, you have to file the I-129 petition based on it by June 30th, 2025. However, if the petition is filed requesting consular processing and requesting the dates October 1st, 2025 to September 30th, 2028, even when it's approved, it doesn't go into effect until the beneficiary goes for visa stamping, goes for H-1B visa stamping, and then comes back in to the U.S. in H-1B status to activate it. Or after the consular processing application is approved, if travel or visa stamping is not possible, the company can file a change of status application after October to change the beneficiary status from L1 to H-1B. So both of those options would require an additional step, either traveling and getting the visa stamp or the company filing an additional application to change the beneficiary status. But that would be the way to postpone the H-1B going into effect without losing the lottery selection. But you still do need to file the I-129 petition by June 30th in order to not lose this lottery selection.
I think so. The gentleman from Ohio got back because his driving lessons were being suspended for 6 months, that he was going at 102 when it is 70 miles per hour. My wife drives at that speed, guys. And I always think that why can't the police catch her? I sit in the car, I tell my wife, don't drive that much, the police is going to catch. And the police are just sitting and they don't catch my wife. I used to think that because my wife goes at such a speed, they can't catch my wife. That's what I thought. But of course, they caught you, Mr. Shankar. They definitely, they might have detained you. So definitely you may have to report that, though. You may have to report that. You may have to report that on the DS-160 if they have detained and arrested. They may have done that with you. Feroza has this question. Got a speeding ticket for 51 in a 35 zone. Unfortunately, in my state, it's considered misdemeanor 3 for speeding over 50. Do I need to report this in any questionnaire? The answer is, Feroza, you do not need to report it. I'm not telling it's okay to do that, but you don't have to report it. As long as you paid it in the proper time or you got the ticket resolved, you don't have a problem. But other gentlemen who got detained, whose driving license has been suspended, definitely I want them to contact the immigration lawyer. As far as Feroza is concerned, no, you don't have to contact an immigration lawyer. You don't have to report that in any of the questionnaires. Just make sure that you keep the documentation that you paid the ticket on the proper timing, print it out, send that to one of your cousin, one of your friend, so that they keep it, just in case it's there in the email, just in case you want to pull it sometimes to show it to anybody if it's required. But as far as the DS-160 is concerned, as far as the H-1B is concerned, as far as the H-4 extension is concerned, as far as the green card is concerned, Feroza, you do not need to mention this anywhere.
GoDaddy says that they have an H-4 and EAD application, or their H-4 and EAD are valid until June 12th. They filed the H-4 and EAD renewal, and it seems like they're saying that the EAD renewal was approved, but the H-4 extension of status is still pending. And they're asking if they can continue working after June 12th based on the EAD being issued, even if the H-4 extension has not been approved yet. That is a little unusual. That's not really supposed to happen. The EAD is only supposed to get approved if the H-4 the extension is approved. So that may have been an error by USCIS of the I-765 inadvertently getting approved while the I-539 was still pending. So it's a bit of a gray area because I would kind of lean towards not using the new EAD after June 12th unless your H-4 extension has been approved by then, just to be on the safe side, because we know the EAD really wasn't supposed to be issued if the H-4 status isn't there. So just to avoid any accusations or problems with potential unauthorized employment, it's probably best not to use the new EAD until your H-4 extension is approved. One thing that you could consider doing to to avoid a work authorization gap is we just put an article on our website today on how you can auto extend your EAD when the H-4 I-539 is still pending. That's not really your situation since your EAD is already approved, but the principle still applies, is that you can go to Mexico, basically by traveling to Mexico and coming in, you can extend your H-4 I-94. And once you come in with the electronic I-94 that's valid until 2028 or however long, then you can use that EAD, even if the I-539 is still pending. So maybe take a look at that article and see if you can use that to be able to use your EAD. The main thing to make sure of is if you are going to try that with travel, you need to travel and come back before June 12th. Don't try it after June 12th unless your H-4 is approved by then.
Rohit asked this question for the DUI. Can I go for the expungement? Will it have any positive things if he goes for the expungement? The expungement is not going to work any good whatsoever at all for the immigration purposes. It may work good for your employment and some other purposes. For the purpose of the immigration, it is no good. It is not good. You still, even if it's been expunged, a lot of criminal lawyers will say you don't have to mention this anywhere. That is wrong. You consult an immigration lawyer for the immigration issues. Criminal lawyers are different, immigration lawyers are issues. If you have been detained, if you have been arrested, and then later on that case has been expunged, though, you still need to report you've been detained, you've been charged with a crime, and later on it was dismissed or whatever happened afterwards, you can mention that. But the expungement does not have any good impact on immigration. Also, questions coming from Ram. My case was dismissed 10 years ago when I was a student visa. Now I'm an H-1B for 8 years. Does USCIS look into 10-year-old cases? The answer is yes, yes, and yes. They do look into that for that long period of time.
We have a question on how do I know what my most recent address was with, updated with USCIS as far as the AR11, I assume. So yes, technically all non-citizens who are physically in the United States are required to file the AR11 change of address form to update USCIS whenever their residential address changes. If you don't remember whether you filed that for your current address, I would say just go ahead and file it. It's a very simple form. I believe online it will also, it used to at least show you your old address and what it, the new address it's changing to in the system. So you may be able to confirm there. But if you're not sure, just go ahead and fill out the AR11 online. It's very simple.
Typically, when you file the H1, H4 adjustment of status or any application, the USCIS is supposed to get your address there because you mentioned the address there. But as Rebecca has pointed out, if you have any doubt, just go on to ar11.gov. It's some .gov site, make sure, and then you update it if you have any doubt. Please don't fall into the trap of the people who are calling or sending emails saying that you didn't fill the AR11. They are going to come and arrest you in the next 20 minutes. If you don't pay them certain money, it is not almost, it is always fraud people trying to take advantage of our situation right now in USA. Don't fall into that trap. Please don't pay money to those people, though. No immigration authorities have ever done any bad activity with the people who have not done the AR11 update. We're just telling as a precaution right now. So definitely these are fraudulent agencies. Anybody who's asking money, and they're telling that the government official, especially, and they want the money right now, it almost always ends up to be fraudulent people, guys.
Rakesh has a question about his changing his underlying basis of his pending I-485 from EB2 to EB3. So Yes, if you are still with the same I-140 petitioner, you're still with that employer who had your I-140 approval, and it looks like you interfiled once from EB3 to EB2. You can file another request to change the underlying basis from EB2 back to EB3. You would just need the company to help you fill out the I-485J supplement. You fill out the first part, and then the company fills out the second part. The company is just filling it out to confirm they still have the EB3 position available for you. So as long as you fill that out and file it, UCI should transfer the underlying basis back from EB2 to EB3. You should only file that if your priority date is current in EB3 according to the final action dates chart. If it's only current according to the filing dates chart, don't file it yet, because there's nothing USCIS can do with it until the dates are current according to the final action dates chart.
Can a person do two jobs for the same employer as a consultant? So ABC company has a H-1B, and ABC's company is selling to work for two clients. Yeah, there's nothing wrong with it. For example, if you're a civil engineer working for a company, they're telling me, okay, work on this project, and then they'll give you an additional project, work on the second project. Can you work on two projects at the same time? Absolutely, you can. Not a problem for IT professionals too.
Rajendra is asking, can his wife, who's a dentist, buy a dental office using her EAD that she got through his I-140 EAD? So if it is the EAD that is issued based on a pending AOS, adjustment of status application, I would say that is probably fine, because as long as your I-45 is not at any risk of getting denied, the EAD is valid for 5 years and should be renewed indefinitely until you get the actual green card. So there shouldn't be any problem with buying a business as an EAD holder in that situation. If what you mean by I-140 EAD is that you have a compelling circumstances EAD, because you for whatever reason you found yourself unemployed and applied for the compelling circumstances EAD, that is a less stable situation. The compelling circumstances EAD is only issued for 1 year at a time. It can only be renewed if your compelling circumstances continue to exist, and it's not really a visa status, and it's can be difficult for that reason to switch from that EAD to another status or to file for adjustment of status later when your priority date becomes current. So if it is the compelling circumstances EAD you're talking about, I probably wouldn't do something like buying a business that you would need kind of continuous work authorization to operate until you're in a more stable situation.
If it is the H4 EAD, though, I would be welcome to move on to buying the dentist office, though.
Mm-hmm.
And also, if she is on H1B, and can she move on to H4 EAD? Yes, she can move on to H4 EAD. Can she come back onto H1B on the same company that she owns? Right now, under the new regulations, they have made it so easy for people owning, let's say, for example, H4 EAD is easier, definitely, though, comparatively. But if ever you lose the job, for example, and then your wife was an H1B before, can she convert into H1B with the same company that she owns? Yes, they have made it very easy right now to own and also be employed in H1B. Even that is possible too. This question is coming from Just a Viewer. I received biometric with no tickets. I have no tickets. Now, what we noticed is that all the people who have received biometrics were on the H1B transfer, H1B, they have some interaction with the police. Detained sometimes, who have been arrested sometimes, charged with some crime other than simple speeding ticket. But here is where the problem comes in. If you don't know what it is, then we need to investigate what exactly happened. There are a lot of times I've had issues where people got stuck in the consulate. The consulate says that they have a criminal history. This guy says, I don't. I never have a speeding ticket. I don't even have a driving license. I never drove any car in my life. Then we went into more detail. We found some problems with them in some issues where there was an arrest warrant issued on them. So these are the things people need to be careful about. I definitely want you to consult. Like, for example, if the guy has a DUI and then he got the biometrics, we know what's going to happen with him. He will go to the biometrics and nothing will happen. If you don't know what crime you are involved in, that's definitely a bigger trouble than knowing what it is.
We have a question from Anil asking, can a perm application be submitted from company B while he is working for company A? Yes, that's absolutely fine. So the perm application is part of the green card process, which is for future permanent employment. You are not required to be working for the company sponsoring your perm right now or ever in the past or at any time before you get the green card. If the company requires you to move on to their payroll at some point as a condition of their sponsorship, the company can require that. But if they're not requiring it and they have this job offer for you and are willing to file the perm on your behalf, that's fine. They can do so even if you have never worked for them in the past.
Question, I've moved into GCEAD, changed the employer. Should I file the I-485J immediately or when they send an RFE? You don't have to file the 485J immediately. You need to do it when they send an RFE or if there is an interview. You don't have to voluntarily file a 485J supplement.
Srinivas is asking if someone has stayed for a year on a visitor visa, the full 6 months, and then filed for a 6-month extension, can they come back within a year? I probably wouldn't. If someone has stayed in visitor status for a full year, I would say they probably need to stay outside the US for at least a year before attempting to re-enter the country. If they try to come back too soon, it's going to look like they are trying to live here in the US rather than visit, and they may not be admitted.
Is it better to give an advance parole versus a H-1B at the port of entry? Now, if you are, let's say, if you're working with company A on H-1B, and then you have a GCEAD in advance parole, and you're not working with any other company, and you're working at the same location where you are supposed to work within, then you may give the H-1B at that point of time. But if you have, let's say, for example, you're working, like some people like to work on Uber in the weekends. I like it. So those kind of things, if you do, definitely advanced parole is better for you.
We have a question from a civil engineer trying to get their I-140 and asking, is there a faster process for them to get an I-140 approval due to their working on national interest projects? Yes. So if you are working on projects that somehow are in the national interest, like especially if they're associated with kind of infrastructure improvement, especially if there's government funding involved, you're a good candidate for a national interest waiver. It is beneficial because it bypasses the perm process, which is definitely the longest part of the green card process. The perm alone takes over 2 years at this point. So you can skip that entirely. You don't even need company sponsorship to file the national interest waiver. You can self-sponsor it, although you may need to get reference letters from managers or coworkers in support of your national interest waiver petition, but it doesn't require the company to officially be a sponsor. And it's probably in your best interest actually to self-petition it, because then it's not tied to your employer. And if you do move employers, you can take the NIW with you, without it being affected by leaving one company over the other. There is premium processing available for the national interest waiver. It's longer than the traditional 3-week premium processing for H-1Bs. It's 45 business days, so it's up to 9 weeks, but it is still much faster than going through the perm process.
Rich is getting married in July. Congrats. And this is for his spouse. He's asking the question. Can the spouse fill out the DS-160 and get a visa date before the marriage? And however, the interview will be after the marriage. So if you're getting married if she's getting married, or if the spouse is getting married in, if your spouse and you're getting, sorry, you're getting married. Let's assume that you are a he and she's a she, and she is getting married in July. She can fill the DS-160 right now, make an appointment right now for the H4, but the interview can only happen after marriage, not before the marriage. The visa stamping cannot happen before the marriage. It's only after the marriage because she's not eligible for the dependent visa until the person is married. But can you make an appointment before the marriage? Absolutely, you can. We told a lot of people to do it, had no issues at any point of time. Anything else, Rebecca, before closing?
No, I don't think so.
Thank you, Rebecca. Thank you for tuning in, guys. But if you have any questions, you can always consult me, Rebecca, anybody in our office at rnlawgroup.com. You please subscribe to our YouTube channel, and also at RN Law Group, you can subscribe to the blog to get any current updates. Don't forget that we do have a daily conference call that allows, very similar to this one, it is a Zoom call where you can come and ask the questions that are available every day, 30 minutes, and you can go to rnlawgroup.com to see what timings it is, because it's 3 different timings are there. And this allows you to ask direct question, because in this YouTube, we don't have more interaction, but in that you get live interaction questions. And we are doing this one past 13 years. I'm doing it from 13 years, 2012 to right now. We're doing it. You can use that. Thank you guys for tuning in. We'll see you next week.
Thank you.